$34. Detention without warrant _return, and Statute of George III, the Statute of 31 Car. 2. Was only applicable to cases of commitment on a criminal charge, every other species of restraint on personal liberty being left to the ordinary remedy as it subsisted before this enactment. An obvious defect was in not providing for cases of imprisonment without warrant. In such a case the party detained had to sue out his remedy at common law. But after the statute, the judges of King's Bench adopted the practice of issuing the writ in vacation in all cases whatsoever. A sensible difficulty was sometimes felt, from the officer's incompetency to judge of the truth of a return made to the writ, for though, in cases within the statute, the prisoner might always look to his legal discharge at the next sessions of jail delivery, the same redress might not always be obtained when he was not in the custody of a common jailer. If the person, therefore, who detained anyone in custody should think fit to make a return to the writ of habeas corpus, alleging matter sufficient to justify the party's restraint, yet false in fact, there would be no means, at least by this summary process, of obtaining relief. The subsequent Statute of George III, however, not only extended the power of issuing the writ during the vacation, in cases not within the Act of Charles II, to all the judges, but enabled the judge before whom the writ was returned to inquire into the truth of the facts alleged therein, and to dispose of the prisoner as justice might demand. Several useful provisions in this statute are made applicable to the Act of Charles II, and may be regarded as expedient modifications of that act. Amos says, it may be questioned whether most of the discrepancies remaining between the two statutes are not to be attributed to the alteration of times rather than to diversity in their subject matters. The curtailment of the power of pardoning, for instance, and the penalty of £500 on judges, would probably not have been inserted in a habeas corpus act made in the present reign, Victoria's. Further, that it seems to deserve the attention of the legislature whether, as in several codes of America, all extant provisions touching illegal imprisonment might, to nearly their whole extent, be advantageously consolidated, thus methodizing many rambling enactments, avoiding unnecessary diversities and repetitions, and making the English law concerning the personal liberty of the subject simple, accessible, and uniform, rendering it in form, as well as substance, a just cause of national pride. 2.